All right. Thank you all for being here today for our second Ask the Attorney webinar this year. And thanks especially to Jeff Tenenbaum and the Tenenbaum Law Group for joining us and presenting this for us. In addition to Jeff today, we also have his associate, Nisha Tucker, who helped
join
Jeff
the meeting,
start the law firm about a year and a half ago. So with that, I'm going to let them introduce themselves. And if you guys have some things you want to talk about at first, let me know. Otherwise, we can jump right into the questions that were pre-submitted.
Thanks, Melissa. And good afternoon, everyone, or good morning to those of you on the West Coast. We're glad, Nisha and I are glad to be here yet again to answer your questions on all things legal issues involving associations and particularly FPA chapters. Everything is on the table today. Last time we did this, I think most of our questions were certainly COVID related, especially focused on meetings and events. These days, in continuing to do sessions like this, there's an increasing focus on workplace issues that we've been getting a ton of questions, and we get questions every day from clients, but also on these sorts of webinars, people wondering about liability issues and vaccination mandates and mask wearing mandates and everything else in between, liability insurance and the like. So happy to take questions on those issues, but also we're happy to take questions on anything else. Nisha and I, like Melissa said, we started Tenenbaum Law Group about a year and a half ago. We've since added a third lawyer, Julie, to our team. We primarily serve as outside general counsel to our clients who are all nonprofit organizations. About 2/3 of them are associations and the other third are other types of nonprofit organizations. So there's virtually no legal issues that we don't deal with. So everything from tax exemption and UBIT to contracts and corporate governance to copyrights, trademarks, employment, conflicts of interest, you name it, there is no shortage of issues that you guys deal with on a daily basis. And so any of that is fair game for today. I've been doing this now for 26 years, all of it in Washington, D.C., where we're based as an attorney in private practice representing associations and other nonprofits. Nisha spent most of her career in-house at an association and also at an association management company, managing and providing legal counsel to associations. She's been doing this for about 14 years and is also very experienced in the area. Nisha also really takes the lead, I'd say, of the three of us on a lot of the meeting contract drafting and revisions, which has been a huge area of focus, not just related to COVID, of course, because everyone has concerns about potential meeting cancellations and poor performance leading to potential attrition penalties and things like that. And we, of course, deal with those issues on a daily basis. But also just the regular contracting process for future meetings and whatnot. There's a lot that we have learned not only through COVID, but just generally a lot of kind of tips of the trade. We get a lot of questions frequently, such as, what are the most important provisions to have in your hotel and convention center contracts? What sort of things are you adding or revising due to COVID? What sort of trends, pushback are you seeing from hotels, convention centers and whatnot? And so I particularly wanted Nisha to be able to speak to those issues and anything else that might come up today. So with that as background, and as some of you had submitted some questions in advance, and if you did and you're on the call, please go ahead and just unmute yourself and pose those questions. But we really want to keep this kind of free flowing, kind of rapid fire, shoot away, and we'll try to answer as many questions as we can before the hour's up. So who wants to get us started?
I will go ahead and ask some of the ones that we received in advance. First is, as some private businesses are now doing, can we, as a local chapter, mandate masks and or vaccination, proof of vaccination, or testing for event participants? Or would this have to be a policy at the FPA national level?
Okay, so first thing that you have to understand is that there are some federal laws, particularly Title VII of the Federal Civil Rights Act and the Americans with Disabilities Act, that apply in the employment context. Well, the ADA only applies if you have a certain number of employees, which most of you probably don't. but there are a lot of state equivalents of the Americans with Disabilities Act, often that do apply to all employers in the state. So let's just presume for purposes of this discussion that the ADA or the state equivalent applies to your chapter. In the employment context, so rules regarding vaccinations and whatnot, mandatory vaccinations for your employees are very different than the rules and what you can do when it comes to mandatory vaccinations for conference or meeting attendees. And that is because those provisions of the ADA and Title VII of the Civil Rights Act that protects against religious discrimination, those provisions do not apply to conference and meeting attendees. And the conference and meeting attendees don't have the protections that come from those two statutes. So the short answer is, can you mandate, let's deal with each one separately. Let's deal with the workforce first. Can you mandate vaccinations for your staff? Now, of course, if FPA National, has some sort of policy that's mandatory on the chapters, whether saying you have to require vaccinations or you're not allowed to require vaccinations or anything like that. Of course, we're talking about COVID vaccinations. That's a different story, and I'm not aware that there is any such policy. So presuming there's not, then chapters are free to do what they would like, but because of those two federal laws or the state equivalents, you can require, the EEOC has said it is lawful because COVID is a dangerous, deadly virus that poses a risk to people in the workforce, that it is proper and appropriate to mandate vaccines for your staff if you want to. You don't have to. Some employers are mandating it, many are not, and many are taking kind of an in-between approach where they're not mandating vaccines, but they're saying if you're not fully vaccinated, then when you're in the office, you have to wear a mask and socially distance at all times, including on travel for work and whatnot. Trying to provide an incentive for people to get vaccinated, but also to protect everyone in the office. That's probably the most common approach that we're seeing. However, you have to make exceptions and provide a reasonable accommodation for those that have a sincerely held religious belief that prevents them from being vaccinated, or that have a qualifying medical condition that makes it dangerous for them or unable to get vaccinated. And there's a whole set of rules that on the federal level, at least from the EEOC, about what sort of proof can you require in terms of a note from someone's doctor, and what is a qualifying disability and whatnot.
Hey, Jeff, I'm gonna stop you there because the majority of the people on this call, this does not relate to. So individually, if any of you are interested in this, contact me and we'll connect you with Jeff off this webinar. Let's focus on events.
Okay.
Most of the attendees here are not employers.
Okay, then as long as you recognize, you got to make exceptions for sincerely held religious beliefs and medical conditions in the employment setting. In the meeting setting, for conference attendees, those two things do not apply. So you can have a blanket rule that says you are not allowed to attend this conference unless you are fully vaccinated, and you can require proof of vaccination unless you're in one of the states that prohibits requiring proof of vaccination as a precondition of attendance. There are some states, I think there's 5 that we're aware of at the moment, Texas and Florida being the biggest, that have passed laws that, or executive orders that state that, well, a lot of them apply to governmental employers, like governmental agencies, state and local governmental agencies. But those 5, there's a lot more that apply to
join the meeting,
that make it illegal for governmental agencies to require proof of vaccination as, for instance, a precondition of doing business with the state or coming into the office or whatnot. But there's 5 that also apply those restrictions to businesses. Anisha, would you mind posting that list in the chat box?
Will do.
Those 5 also say that businesses in the state are not allowed to ask for proof of vaccination as kind of a precondition of going into that business, like a store, a restaurant, an event venue, things like that. And then one of those 5, Alabama, not only makes it illegal to require proof, but makes it illegal to even ask people if they're vaccinated as a precondition of coming into the business. What is not clear, and because these laws and rules are so new, is whether these would apply to a conference or a meeting organizer like you guys. The way that they're written, and they're written fairly similarly, it does not seem that it would apply Although certainly, an aggressive state regulator might take the position that they do apply to conference organizers. However, they almost certainly would apply to the venue where the event is being held. And so as a result, you really, and by the way, what Anisha just posted, focus on some of them ban government agencies from doing this, but we're not, that's not really what we're getting at here. We're talking about the ones that ban businesses. And so if you're in one of those 5 states that ban businesses from requiring proof of vaccination, and that applies to, say, the hotel or the restaurant or the convention center where you're holding your meeting, that probably means that it would be illegal for you to ask for proof of vaccination in order for people to attend your conference. It does not mean, except in Alabama, that you could not ask people to voluntarily self-certify that they are fully vaccinated. You could do that, but you cannot ask for proof. These laws are evolving and changing on a very, very regular basis. And so if you're going to hold a meeting, you want to check in your state, or whatever state you're holding the meeting in, to see what is the current status of those laws or rules in your state, because those laws, if those laws don't apply in your state, then you can say no one can attend our conference unless they're fully vaccinated. Or if you're not fully vaccinated, you have to wear a mask and socially distance at all times. You're free to do that without any exceptions. But if any of these state laws come into effect, and if you're in one of those 5 states, then that can be a real problem for you in that regard.
Hey, Jeff, point of clarification. Nisha's note says that we're banned from asking for proof of vaccination, but does that mean that we couldn't require attendees to be vaccinated and just have them self-attest but not require the proof?
Yeah, that's what I just said, that
Okay.
those 5 prohibit businesses from asking for proof of vaccination, but one of them, and Anisha, we should probably put an asterisk next to Alabama, one of them Alabama makes it illegal not only to ask for proof, but to even ask people if they're vaccinated as a precondition of going into the business or participating in the business. The other 4 just proof. That's why I said if you're in Florida, Iowa, North Dakota, or Texas, you can require vaccinations. You just can't ask for proof. You can't ask for a copy of their CDC vaccination card. You can just ask them to self-certify.
Got it.
All right. I know that's a lot to digest, but that's the current state of the rules in this area. Anyone have any questions about any of that?
Before we move on to the next question.
All right.
Hmm.
Shoot away.
Next question. What are some general things they should look for in the post-COVID world as it relates to event contracts? And how can they address a shortfall on attrition?
All right, Nisha, why don't you take the lead on this response, and then I can chime in with some color commentary.
Sure. Hi, everybody. So there's a couple of things we can do, and we need to be able to distinguish between contracts that are already in place and forward-thinking contracts. So the contracts that are already in place, there's a thinking that maybe your hands would be tied because the contract is already signed. The hotel or the venue may not be willing to go back and reevaluate certain provisions, but there's nothing to stop you from trying. So we want to try to do a room block review provision and just try to let them get the hotel to let you reduce your liability of the room nights without any consequence. So let us reduce up to 20%, and then we'll use that new number as our attrition number. A lot of hotels will push back on that, but then the alternative is to just try to do an addendum to remove attrition altogether, which is sort of lofty, or to at least give yourselves more wiggle room. So typically we're seeing about 80% is the attrition number. If you can get it down to 70 or so, that helps. So those are for sort of the—
Nisha, why don't you explain, just for those who maybe are not as familiar, what that 70 or 80% figure means in the attrition context?
Sure. So when we're looking at hotel contracts, your room night requirement, let's say you have guaranteed 1,000 room nights with the hotel. The attrition number lets you have that wiggle room of about, that 20%. So if we're looking at 80, you have to satisfy 80% of your 1,000 rooms. If you fall within that range between 80 and 100% of your room night block, you won't be issued a penalty. Anything below that number, if you hit 79% of your room block, you're going to be issued penalty for falling short and have to make up that amount to meet the 80% threshold. So those are really the ideal options for contracts that have already been signed, is try to reduce the attrition in just a simple negotiation with the hotel. When we're looking,
and one thing to interject, but like every negotiation, you need to have some leverage, right? Just asking a hotel to reduce your attrition penalties or your guaranteed minimums for sleeping rooms and food and beverage, most hotels aren't going to just say, oh, sure, we'll just reduce it for you. But sometimes they will if you have some leverage, like perhaps you're a long time, customer and you've been holding your annual conference there for years and years, and there's goodwill built up. Maybe you haven't signed a contract for next year or the year after, and they want to incentivize you to come back and sign a new contract. Sometimes in some of the difficult negotiations we've had during COVID, that's one of the biggest tools in the toolbox is leverage to get a hotel to say either allow you to cancel or move your meeting, to somewhere months down the road when COVID is less of an issue, or to be able to significantly reduce your attrition penalties and your guaranteed minimum. Sometimes signing a new contract for a future year is one of the best pieces of leverage that you have. You don't want to lead with that, and you don't want to do that if you don't have to, but you need to find any kind of positive and negative leverage that you can to try to incentivize the hotel to reduce those numbers. And maybe, for instance, you convince them to reduce your sleeping room block, but you sweeten the pot by maybe spending a little more on food and beverage to make it a nicer event, or something like that on the food and beverage front. So that's kind of a piece of positive leverage. But you got to find whatever you can, whatever you have, to try to compel and convince the property to reduce your attrition.
And going along with that, to be able to go in and ask that question, the hotel will appreciate, I think, that you're not trying to cancel the event altogether. The hotels are still looking to put revenue on their books from this year that so many events have been canceled. So the willingness to move forward, even if it's a smaller event, helps grease those wheels a bit. So forward-thinking contracts, things that you're negotiating now, even thinking beyond, the force majeure provision, which everybody suddenly jumped on, a provision that hasn't really been considered in the past, suddenly became the most popular topic last year when it came to event contracts, right? Things that are out of your control. That may not work anymore just because COVID is not an unforeseen circumstance. So we're looking at other ways to really help groups protect themselves when they're looking at events moving forward. Like I said, for the existing contracts, one of those ways to do that is to ensure your contract has a room block review provision. So if your event is 2 or 3 years or more down the line, put in there something that says at 6 months prior to the event, at 12 months prior to the event, 3 months in intervals, that you have the right to review the room block and increase or decrease your room block and function space by up to X percentage, let's say 20%, without penalty. So that is an addition to those attrition numbers, right? So you'd be able to say, at 6 months, we've realized we don't have the registrations we're anticipating. We need to reduce our room block. For now, we're going to start at 10%. And in 3 months, we're going to reevaluate. And if we need to change it again, we have that aggregate 20%. We can modify our room block and our function space. That gives you the flexibility to stay realistic with your numbers without having to commit something too high right up front. So that's definitely one option that we have been putting in almost every single contract we've been doing for our clients the past 6 months. The second is that attrition clause, keeping it under 80% if possible, 70 to 75%. Some hotels, like Jeff was saying, if you have a really good relationship with a hotel chain, a specific hotel, a sales manager, and it's a larger event, some hotels are willing to waive attrition altogether, meaning they're not going to hold you accountable to any minimums whatsoever, which is really the ideal, but it's going to depend on your relationships and the size of the meetings for those. So those are the two big ones right now, are room block and attrition. We are also looking at other smaller things you can do. The first is putting in a bankruptcy clause. If the hotel files for bankruptcy, you can get out of the contract without liability, because unfortunately that's happening everywhere. It's not just the hospitality industry. It's not any one industry. Everybody got nailed with COVID. And we have seen here in DC, one of the largest convention hotels in the city went bankrupt. And we had, Jeff, I think, what, 10 or 15 clients who had future meetings there that they were then struggling what to do. Luckily, half of those clients had a bankruptcy provision in their contract that said they could get out of the contract without liability, and they weren't going to have to hold off and wait for something to happen, right? For the hotel to actually close, they could just wait for bankruptcy. That was done. They're out of the contract. So that's one. The other thing we really want to look at is your deposit amounts. Hotels are seeking large deposits now. This is not something we saw pre-COVID, and that's specifically because when groups were able to terminate for force majeure, meaning unforeseen circumstance, they're terminated without liability, the hotels had nothing to fight with, right? They weren't holding anybody's money, so they had no leverage to get the group to play ball. Now we're seeing hotels on a minimum of, a $200,000 contract are saying you have to pay us a $50,000 deposit at the time of signing. And that's something we strongly, obviously, advise against. You don't want to have to put so much money up front because it gives the hotel the leverage when and if you're trying to terminate the contract for some force majeure reason. So once they have that money, you trying to fight to get it back is incredibly difficult. Jeff, you have something to add?
Yeah, we saw last year in the probably 600 or 700 event contracts that we worked on, most of whom were trying to cancel without penalty under the force majeure provisions. We saw a big difference in how the hotels and convention centers responded in the negotiations when there was a big deposit and when there wasn't. And essentially, anytime there was a big deposit, the hotel, we were not getting it back for the client. And it emboldened them, and they took kind of harder lines as well in the negotiations. What we we're able to do in a lot of those cases, though, is get that deposit applied to a future year contract and not having it just paid as cancellation penalties. Because they're just going to keep it as cancellation penalties, you get nothing for it. But if you can say negotiate a future year contract and then have that money be applied as a deposit to that future year, that's a negotiating tool that we used a lot. And even in some of the rebook negotiations, sometimes it was actually, as opposed to the hotel just assessing them for huge cancellation penalties and sending it to collections and coming after them, there were some cases where it made sense for our clients to actually pay some additional monies, but to pay it as a deposit for the future year contract instead of cancellation penalties. So if you do have to pay, you want it to be a deposit, not cancellation penalties. But in these new contracts that Nisha is talking about, you really want to try to minimize the deposit as much as possible. And if you do have to pay more deposit money than you'd like to, at least have it spread out. So don't let them, require you to pay it all up front upon signing or something like that. But have it spread out over whatever period of time in equal installments, 4 payments or something like that to mitigate the downside risk.
And similarly with the cancellation penalties, it's the same thing. We're seeing that, before it was 20% of cancellation penalty and then 40, 60, 80, and it kept increasing as you got closer to the event. Now we're seeing, immediately upon signing till a year before the event, 50% of cancellation penalties are due. So we're revising all of those provisions too, to be a little more reasonable in terms of the staggering of the cancellation penalties and when they become due.
Question from the chat. How would these sorts of revision to the contract 6 months out, et cetera, how would that relate to something that isn't a hotel with a room block? If you're booking just a restaurant for a party?
Most of the restaurant contracts we've seen or venue contracts have something similar, that you have to give a final number by a certain date out. There's nothing to stop you from putting in a provision like that in any other contract that says, we anticipate this many people as of the date of signing, but we reserve the right to reduce or increase up until 3 months or 2 months or whatever is reasonable for the actual venue to mess with those numbers up to a certain degree.
Yeah, so the same principles that apply to room blocks apply to food and beverage. It's just with a hotel that has sleeping rooms, you have both. With a convention center or with a restaurant, you just have one. You just have the food and beverage. But these same principles about deposits and attrition and cancellation penalties, they still very much come into play. One of the biggest differences is that if you get hit with cancellation penalties or attrition penalties, frankly. For food and beverage is money that you are going to spend anyway. You, the chapter, you, the association, is going to spend. Whereas the sleeping rooms is largely money that you would not otherwise be spending if the event gets held. It's coming from your members, from your attendees. Yet you have to pay it if you get, come up short on the sleeping room block, whether it's attrition or cancellation, if you outright cancel the event and you can't get out under force majeure. So keep that in mind. That's partly what made last year and coming into this year, but especially last year's cancellation so difficult for so many associations that all of a sudden they're, being hit with massive cancellation bills for monies they didn't have and were never going to be able to earn, because if you're not holding the event, you're not going to have your attendees pay for the sleep. So keep that in mind.
Carlos, did you have a question? You lit up. Oh, and now he's muted. Okay. Nisha, anything else on hotel contracts, or can we move on to the next question?
Move on.
Yeah, one other thing, Nisha mentioned a bankruptcy provision, which is important. Another thing that we always put in there, which has come to pass and even been accelerated due to COVID and the economic hardships in the hotel industry, and that's change of management. You want to have a provision that says if the hotel changes management or a restaurant or anything, that you have the right to get out without penalty. We've seen that happen sometimes, a downward change in terms of the quality of the management and whatnot, and you want to give yourself flexibility. And usually that's a provision that most hotels will go along with. I mean, there are lots of other provisions in these hotel contracts that we work on. So we're not trying to suggest that these are these tend to be, the most important things, but there's a lot of other things that we kind of typically work on and include in a hotel and convention center and meeting contracts.
Thanks, Jeff. One of the other questions we received was, does FPA have a standard hold harmless agreement that we should have in-person participants sign prior to attending? The answer to that is no, FPA does not have a standard. However, after the last Ask the Attorney webinar, we did provide some suggested waiver language for you, and that is posted in our community on Connect. Jeff, with the updates to regulations in the last couple months, do you have any updates to those documents, or are they still valid?
Yeah, so Nisha, can you email Melissa when we're finished, kind of what we've been sending out to clients? We have a kind of a model, most people refer to it as a liability waiver, basically saying, I attendee recognize that COVID is a dangerous virus, and FPA can only do so much to protect us. And if I contract the virus at or in connection with your event, I agree not to hold you liable for it. That's basically what it says. And should you be using those liability waivers? Absolutely. To me, it's a no-brainer. They don't always hold up in court. Like, for instance, if you are, if you're found to have engaged in gross negligence in how you conducted the meeting, a liability waiver is generally not going to be enforceable, but you're usually not going to engage in gross negligence or intentional misconduct. And so generally they will be upheld. So we'll send you some samples that you guys can use, and they do continue to evolve because, what we usually have in there is, in addition to the liability waiver, we say, you agree to abide by all of our rules of attendance, such rules which might change, on a daily basis. As you know, like in DC and California and some other states, there's now an indoor mask mandate that didn't exist a few weeks ago. So if there's an indoor mask mandate, doesn't matter whether you're vaccinated or not, you still have to wear masks indoors if you're holding your event in one of those states. Even if you're in another state, we have some association clients who are requiring masks even for the fully vaccinated in states where it's not legally mandated. So you want to make sure that they abide by whatever your rules are and that you have the right to change those rules on a regular basis.
With regard to the waiver, is it enough to just post it with the event registration so that, you know, if they register, they're sort of tacitly agreeing to adhere to that waiver, or do they have to sign something or check a box, or
Yeah,
what's
it's
your
great. It's a
recommendation?
great question. Generally speaking, that's one of the reasons when liability waivers get struck down by courts is when you know, the person says, well, I didn't even realize it was there. I didn't realize I was agreeing to this. Now, granted, in the past, we've always used kind of you know, the terms and conditions of your conference and your meetings to throw a whole bunch of things in there, like I agree that you can take photos and videos of me and use it without my permission and things like that. By, you know, by registering for the conference, I agree to abide by all of your rules. But here, because it's an express liability waiver, for absolute certain, the best practice is to have folks either sign or click and accept that they agree to the liability waiver. Make it clear, prominent. Don't use too much legalese, you know, so that no one can say that they didn't understand what they were, you know, agreeing to, and then keep a record of that. Someone asks here, if someone attends a meeting and later finds out they had COVID and alerts you, what procedures do you follow? Yeah, you know, we're getting this question a lot, and you need you want to balance the. It's not a HIPAA issue. A lot of people think it is, but it's not, because HIPAA only applies to healthcare providers and certain associates of healthcare providers. But it is an Americans with Disabilities Act issue in that the ADA and a lot of state equivalents make it illegal, at least in the employment context. And most of you guys don't have employees to share confidential medical information. There are claims that even a conference attendee might be able to make if you were sharing confidential medical information. You should never, you know, share the identity of, say, someone who said they had COVID. That being said, even the EEOC in the employment setting has said it's okay to do contact tracing and things like that. So you could say, you know, John Doe has reported that he contracted COVID. You know, we understand you might have been around him. You know, we want to let you know. Things like that are perfectly acceptable. What a lot of our clients are doing is developing protocols for, you know, what happens if there's a, you know, a positive test of someone at the event that you're holding. You know, what sort of medical, you know, access to medical facilities are nearby. We have some larger conferences that are even having, you know, paying for like I don't know if it's a physician or a trained medical professional, you know, to be on site at all time during the meetings, you know, having protocols for quarantining people if they test positive, things like that. Oh, and by the way, I should have mentioned earlier, when I said for conference attendees, you know, either show proof of vaccination in the states where you're allowed to, or have to wear a mask or socially distance as being kind of maybe the most common construct we're seeing. I should have added, it's usually proof of vaccination or a negative COVID test within the preceding 72 hours. That seems to be kind of a trend that we're seeing more and more in places that require either proof of vaccination or that recent negative COVID test. Someone asked here.
Can I ask a clarification on that first? Not the COVID test, but you said that it was acceptable for an association to let people know that they may have come in contact, but it's not then legally required, or is that just an ethical, moral dilemma?
So it's a good question. There's definitely, I mean, I'm not aware of any actually state or city or county that mandates that. It's not, there's no express requirement that you do that. It comes back to, you know, the basic issue of when is it possible for my association to be held liable if there's a COVID outbreak at my event? And the basic answer to that question is, was your association negligent in how it held the event, how it conducted the event? That's the basic standard. You know, did it abide by the prevailing standard of care that exists at the time? What is that standard of care? Well, you first look to state and local mandates, because the feds don't really have any mandates. They have a lot of guidance that's very relevant, like from the CDC, but they don't generally have mandates, at least outside like airports and train stations and whatnot. But a lot of states and cities and counties do. So you first have to consult whatever the mandates are in your city, state, and county. Then you look to the CDC, because that's kind of where the principal guidance for large meetings and meetings generally is coming from on the federal side. And there is guidance that the CDC has put out for meetings and what you should do to safely conduct meetings in the era of COVID. And you want to do as many of those things as you can, and you want to get the hotel or the meeting venue to do as many of the things that they can or willing to do that are kind of fall within their bucket. You know, things like sanitation and ventilation and things like that. You know, the more of those things you do, the less likely it is you're going to be held negligent. So, you know, to yours, that was kind of the background for the question, but the specific question, you know, is, do we have an obligation to tell others? I think if you know that someone tested positive that was, you know, in a crowd at your event, and you can do some contact tracing to inform others, you know, that they might have been exposed, especially if it's a conference without masks, you know, I would say, yes, you should try to do that. That'll help to show that you're not negligent in how you're conducting. Do you have some express obligation to do so? Especially if you're not sure, you know, if someone had COVID when they were at your conference, or maybe they contracted it later, you know, it's a judgment call. But I'd say I would recommend, if you were asking me as counsel, I would probably recommend err on the side of trying to inform people, not disclosing necessarily identities, except, you know, if you're doing some pure contact tracing, but I probably would err on the side of doing that.
Thank you. Another question from the chat is, especially in states where there are, or counties where there are now indoor mask mandates, does this mean that chapter staff and or volunteers have to police people in order to, you know, uphold those laws, or even where there aren't laws, if it's part of our waiver? What's our,
well, and yeah, not part of your waiver,
there is chapter staff,
right? If that's part of your rules, we've gotten this question a lot, and what I've been advising clients is that if you know, you don't have to be, you know, the brutal mask police every single time you see someone, you know, not wearing a mask or not wearing it properly, not covering their nose or something like that. You know, do you have to you know, run over to them every time? Not necessarily, but if you see someone who's kind of a repeat offender, they're almost purposely, what if we know someone is not vaccinated and attends an event not masked? What should we do? See, that's a perfect example. If you know that's the case, then yes, you absolutely should enforce it. Again, it's not that you don't have some legal obligation to enforce the law. You're not law enforcement. However, you are, you know, the hotel is not likely going to do that, or the restaurant staff, they're not likely going to enforce it. And if you want to be able to demonstrate that you were not negligent in how you conducted the meeting, and I think especially where you see a situation like Lori just asked about, or if you just see a repeat offender, then yes, you absolutely should do that. And in your rules, you should reserve the right to kick someone out if they refuse to abide by the rules. Look, no one likes wearing masks. At least I don't know anyone who does, but that's where we are right now in the state of the pandemic, and some states require it, and in other states your association might decide to require it, because that's what it takes to make everyone else feel safe coming to the event, unless you have a mandatory vaccination requirement or proof of a negative COVID test.
Another question in advance was, is D&O insurance and state volunteer laws enough to cover volunteer liability? In other words, what liability do our volunteers have personally for events where something may occur? Or does that depend on the insurance?
So first off, directors and officers liability insurance, there's no standard form. It varies significantly from policy to policy. But one of the things, there are some common elements, and one of the elements is that D&O insurance does not cover any claims for bodily injury or property damage. Bodily injury being the operative one here. So if someone files a claim, you know, that they contracted COVID at your event and that you were negligent in how you conducted the event, that's likely going to be excluded under the exclusion for bodily injury and property damage. In the past, those sorts of claims would have been covered by what's called commercial general liability insurance, completely different from D&O. And that's what a lot of people refer to as slip and fall insurance. And that's the kind of insurance that would cover your events and accidents that occur. It does cover bodily injury and property damage. However, not surprisingly, since the pandemic, all of the insurance carriers, and that is a standard form, are now excluding coverage for communicable diseases, including COVID. So there is basically a COVID exclusion in all new policies. So if your policy has been written and bound since the pandemic, especially in the last 6 months or going forward, you're not going to be able to have coverage in your policy there. Federal and state volunteer protection laws are very helpful in protecting unpaid volunteers of nonprofits from a lot of liabilities. In addition, the corporate shield itself, presuming your chapter, and I think all of you are incorporated, the corporate shield that comes from your chapter's corporate status as a nonprofit corporation provides a liability shield between the liabilities of the chapter and personal liabilities for those who run the chapter. So, generally speaking, you don't even get, someone that's filing a lawsuit can't even get to the volunteer leaders or even the staff because of that corporate shield. If they could overcome that somehow, you got federal and state volunteer protection laws. In addition, most, if not all of your chapters probably have a provision in your bylaws that provide for indemnification in the event that you get sued because of your role as an officer, director, or staff, that you will be indemnified, meaning the chapter will protect you, pay your legal fees, pay any judgments or settlements against you. So you have all those multiple layers of protection, even if you did not have insurance coverage. So it's not something that I would lose any sleep over.
So a lot of our chapter executives are not employed directly by the organizations themselves, but by association management companies or
Right.
meeting planner firms, or are self-employed. What coverages do those individuals have? Do those same corporate shields that you just discussed, do those protect a contract employee or contractor?
So it's a great question, and we represent some of the largest association management companies in the country, so we're intimately familiar with the model and represent a number of associations that are managed by AMCs. A few thoughts here. First off, things like indemnification are not going to apply in that context. They generally apply just to officers and directors. Depends how they're written, but even if it's at officers, directors, and staff, you're not staff of the association, so the association's indemnification clause is not going to apply. Where a lot of the protections are going to, first off, you still have the protection in that, chapter is a corporation A and AMC is corporation B. So because of the corporate status, the corporate shield between them, generally speaking, the AMC should not be liable for, the liabilities of the chapter. However, if it could be shown that the AMC was responsible for creating those liabilities through your actions, then it is conceivable that someone could reach through and sue both the chapter and the AMC, saying that, for instance, the AMC was negligent in how it operated the chapter, or you were negligent in how you operated the chapter. Now, what's really important to focus on is the contract. Now, I don't know who I'm speaking to here at the chapters, your AMC hat, but depends what hat you want to put on. But if I was putting on, your AMC hat, and then like we do when we represent AMCs and we write their contracts and review and, their contracts with their association clients, that's where it's really important in the contract to try to spell this stuff out, to include indemnification provisions and their limitations of liability. Another thing we see a lot, and actually got involved in some litigation over this, how you sign contracts and anything else, but especially contracts on behalf of the chapter. It's really important. What you want to do is in your own AMC contract with the chapter should specify this, but whenever you are signing contracts on behalf of the chapter, presuming you're the signatory, you want to make sure you're signing on behalf of the chapter and that you're not signing in some way that's going to bind the AMC to that contract. So be careful, what titles you use and things like that, to make clear that you are signing as an agent or representative of the chapter and on behalf of the chapter, even sometimes spelling that out. I was involved in a case where the association itself kind of went just dissolved. It went under, and there was a big liability to a hotel, and the hotel hired an attorney to try to figure out if they could recover some money, and they issued discovery to the AMC to try to figure out, because the AMC unfortunately had its representatives kind of signing in an improper way, and it made it look like the AMC was potentially on the hook for these liabilities under the hotel contract. So focus on that for sure.
Thank you for that. The only other question I saw in the chat is anyone writing special event insurance with a loss of revenue clause? Eamon used to write a policy like that a few years ago, but no longer.
So I think what you're talking about is event cancellation insurance, which very much still exists. All the same carriers still offer it. As of the beginning of last year, all of the event cancellation policies excluded coverage for COVID and other communicable diseases. Now, you used to be able to buy that coverage by paying an extra about 20% higher premium. You could purchase coverage for communicable diseases, including COVID. And a number of our clients had that insurance, and it was an absolute lifesaver for them last year when they had to cancel meetings. One of them got $11 million for one canceled event, which was quite a help to their bottom line for the year. That's no longer. You can no longer purchase coverage for communicable diseases. However, you can still purchase it. There are lots of other perils, and to use insurance verbiage, that can exist. Hurricanes, fires, strikes, transportation shutdowns, things like that, that can cause you to have to cancel a meeting or have what's called enforced reduced attendance. And these event cancellation policies are what's in insurance parlance, it's a form of property insurance, and it does cover loss of revenues. That's exactly what it's about. So, all insurance has gotten significantly more expensive over the last year, in part due to COVID, in part due to some other trends that had started before COVID. Everyone is seeing a spike in their premiums. Event cancellation is not excluded from that. So it is more expensive, but if it's your big annual conference and it's one of your, it's over 50% of your revenue for the year or something like that, it still may be worth buying that event cancellation insurance. But you have to do obviously a hard cost benefit analysis.
One other question in the chat that I'm not sure is applicable to your expertise, Jeff, but I'm going to ask it anyway. We'll see what we get. How can we require members to be vaccinated when we can't require them to indicate their birth dates?
Well, first off, when you say, I'm not heard of any association saying to be a member of our association, you have to be vaccinated. I think what you mean is members who are attending our events. Look, you can, again, unless you're in a state that makes it illegal to ask for proof of vaccination, or in Alabama. And again, those bans, I don't think they apply to the chapter per se as a meeting organizer, but I think they do apply to the venues where you're holding the meeting. So effectively, that's the same thing. So unless you're in one of those states, you can require proof of vaccination or a recent negative COVID test as a condition of attendance. And if they fail to provide you with that proof, if you're asked for proof, or a self-attestation, then you can say, sorry, you can't come. So it's completely up to them. I mean, it's a very easy thing to enforce, I would think. And there actually are some apps out there now. I was reading about an association that contracted with a company called Clear that you might have heard of, that you see them at the airports. They do kind of security screenings in the US at airports. And they have an app, that a conference can contract with, and they will, like all of your registrants, can upload a copy of their CDC vaccination card, their driver's license or government ID, and a photo of themselves to this app. And then it kind of pre-clears you, and then, it shows up on your phone that you're pre-cleared and you're vaccinated for that particular conference. Or you can do it the old-fashioned way and have people show you a copy of their card, or their actual card, or photo of it when they come to your event. And that's certainly an option if you want to do that. And I'm telling you, and except in those 5 states, you're legally able to do that. Whether you want to do it, how it flies politically, as and your chapters are probably no different than the rest of the country. Some of you are in states where that would be very much frowned upon. Some of you are in states where having a mask mandate at your event would be very much frowned upon, even today. And some of you are in states where if you did not do that, you probably will get a lot of people not attending. We're seeing a lot of this is being driven from the ground up, from kind of the attendees sometimes asking the associations, yes, we want you to do this, or we don't want you to do that. No easy solution here. Associations, I think, are going to continue to be across the board on this.
Do you recommend any kind of signage at the event itself regarding the pandemic?
Yeah, I mean, it all goes back to that question. What are we doing to not be negligent in how we conduct the meeting? So yeah, reminding people if they have any COVID symptoms, they should stay away. If you have a mask mandate, having signs that remind them about that. Having signs that don't forget while most of the state and local laws and regulations, it's not usually laws, but executive orders and other regulations, governing like capacity restrictions on venues and social distancing mandates. While most of those don't exist anymore, they've been expired in most state, cities, and counties. It's still, while COVID is still a threat, and it's still part of the CDC guidance that you should require appropriate social distancing at your events, even for those who are fully vaccinated. Again, it goes to that negligence issue. So having signage about that, this is another thing we didn't talk about, but this is something where you really want to talk to the venue in advance. Food service, it is clearly not a best practice and probably would be negligent to have, the classic buffet line where people are self-serving their own food. That's a no-go at association meetings and events, for the foreseeable future. So you need to have alternatives. You either have boxed lunches, or I was at a conference where they had a buffet, but there was a plexiglass shield in front of it, and there was a person behind the shield who was like, tell them what you wanted, they put it on your plate, and then at the end of the line they give you your plate. Or having a sit-down lunch or breakfast where people are bringing, serving the food to your attendees. Those sorts of things. Getting the hotel or the restaurant to agree in advance to do that kind of stuff is going to be very important.
Anyone else have any questions for Jeff or Nisha? Feel free to just speak up. I don't need to be the only one talking. Oh, in the chat, how do you handle small group gatherings for which something like a sign wouldn't make sense and where staff might not be present? Just a liability waiver upon registration?
Well, I mean, the liability waiver is one part of it. And like I said, to me, that's a no-brainer. For a small or large meeting, it doesn't matter. And we're going to send Melissa some of our current samples and models, and you can feel free to adopt those. But that's only part of it. The other part of it is, what are the rules that you are imposing on your attendees? Whether or not the staff present or not, doesn't matter. You want to have rules. The rules might involve mask mandates and social distancing. The rules might say, if you have a fever or other COVID symptoms, don't show up. If you're not feeling well while you're there, leave. Anything else that you might, any other rules that you might impose, you want to make those clear, even for a chapter member study group that's meeting in person. And part of that liability waiver is kind of an agreement by the attendees at that event that they agree to abide by your rules. And those rules, are likely going to change on an ongoing basis.
Anything else? I'm not seeing or hearing anything, so I think we can, oh, nope. One more from Lori. Can a liability waiver protect chapter executives who are independent contractors and not incorporated?
So what I've been referring to is a liability waiver where the attendee is releasing the chapter itself from liability. You could certainly expand it and write it to release the chapter and the AMC that manages the chapter, or the chapter and the individual exec who doesn't have a corporation but is managing. I mean, you could have it extend to whoever you want. You would just need to specify that in how the waiver is written. And so, yeah, in this situation, it actually probably would make sense to expand the liability waiver to include both the chapter as well as the AMC / individual chapter leader who's managing the entity, but not as an employee. If someone is employed by the chapter, then generally speaking, the waivers, like most of them that we work on, will say, attendee John Doe hereby releases the chapter and its officers, directors, employees, and agents, things like that. So actually, as I think about it, a lot of them are written in a way that probably would, by the way it's defined, include like the managers who are not employees of the organization. But to be safe, I'd probably specify it specifically in the waiver.
All right. Thank you, everyone, for your participation and your questions. They were very thoughtful. And to Jeff and Nisha for your really thoughtful, informative responses. This was really helpful to me. I hope it was helpful to you all as well. And I will be sending out the recording and the updated liability waivers when we receive them.
Right.
Thanks, everyone.
Everyone, take care.
Bye.